This episode was originally a bonus episode for our partner institutions at our Debatable With program. We recorded it last December 27th, and we gave exclusive access to our partner institutions at the Debatable With server.
If you want to know more about the program, you can contact us at our email at podcastdebatable@gmail.com. By the way, this is not the first time we did this. It's like the fourth time we did this. We even tried like making AI versions of us to, read the ad read, and it was really bad. I'll put the AI version here too.
Let's hear the AI Nina and Kyle.
This episode was originally a bonus episode for our partner institutions at the Debatable With program. We recorded it last December 27, and we gave exclusive access to our partner institutions at the Debatable With server.
If you want to learn more about the program, contact us at our email at podcastdebatable@gmail.com. That was so scary. It's a good thing, Nina, that there are ongoing efforts to protect workers and creatives from AI.
Wow!
Wow. Anyway, that's the episode.
Welcome back to another episode of Debatable with your hosts, Nina and Kyle. I'm Nina.
I'm Kyle, and today we are going to be talking about a kind of new thing. I think this might be a bonus episode if it's too short. If it's long, this might be a real episode. But anyway, today we're going to be talking about House Bill number 9448, which was filed in the 19th Congress. This is a very recent bill. It was in the news yesterday, I think.
What is it about?
It
It's
is
not very nice to listen to, and it's just a number.
Yes, so House Bill 9448 is an act regulating the use of artificial intelligence and automation systems in the labor industry and for other purposes. Now, we have to first stress that we are commenting on a bill, so this is not law yet.
Yes.
So we are just speculating on what might happen if ever this bill, as is, be passed. We're going to be commenting on various things. We have a copy of it right now, right in front of us. We're going to be commenting and reading it for you for the first time. Yeah, so
Just clarify first that when something's a bill, it still has to go through multiple readings, and that's where they have debates and discussions within the Senate and House of Representatives, and this is where a lot of fine tuning that will take place, and we're not sure if this will become law. We are just commenting on the current state it's in because we find it to be very interesting. I think that it says a lot about AI and how much distress people are having, either in terms of speculation of what it can be
yes.
and maybe even actuality, because I know a lot of people's work is already getting disrupted because of the rise of artificial intelligence.
And this is not legal advice. Just like generic disclaimers, this is not legal advice. We are not experts on this. We just want to give our own insights about this bill as we're reading it. As Nina mentioned, there needs to be several readings. Dapat there should be debates and deliberations. And if you've watched some of these deliberations before, they sometimes have it on YouTube. They try to suggest revisions, even like word per word revisions. But there are lots of bills that are filed that unfortunately don't see the light of day. They kind of die on the floor of Congress. So hopefully this is something that will be actually debated on in the future. So again, it's an act regulating the use of artificial intelligence and automation systems in the labor industry and for other purposes. But the short title of this, which you can find in section 1, is the Protection of Labor Against Artificial Intelligence Automation Act. Yeah, so the first thing that I want to talk about here is section 2. Section 2 is a declaration of policy. So basically, it is a clear statement of the objectives and principles and goals that the law, if it becomes a law, what would it intend to achieve? In this case, let me just read it out. It reads, it is the policy of the state to ensure protection and safeguard the livelihood and security of tenure of its citizens through regulation of the possible implementation of AI and or automation technologies in the workforce. The state is mandated to strike a balance between the right of business owners or employers to reasonable return on investment aided by technological advancements and the preservation of employment opportunities for the people. So, breaking it down, is essentially the state wants to make sure that people don't get fired unjustly because of AI. That's what you mean by security of tenure. Security of tenure means that you have the right to keep your job, and there are only some grounds that an employer might use to terminate your employment. At the same time, the declaration of policy says that there should be a balance between the rights of businesses to be efficient and the right of laborers to feel secure in their jobs.
So I have a question though, is why do they need to do this? For instance, I think we've already passed laws that to some extent protect people from the rise of automation. This has been an issue even back in the day with the rise of machinery that can, like put in gears and different tools that used to be done by hand. Why do we need to make the distinction? Can't it fall under that?
Well, technically, even today, we have a rule where generally you can't fire workers because
Yes.
they have security of tenure. But one of the authorized causes under the labor code for when it is okay for an employer to terminate a worker's employment is the installation of labor saving devices. So that's what you meant,
Hmm.
automation. There are a lot of requirements that employers need to do in order to actually go through these types of things, but that's for later now.
Okay.
Anyway, the reason why we have the declaration of policy, because you might be wondering, like, why should we even have this? Isn't this a useless provision? Like, isn't this just filler? Because when I was in law school, this was the type of provision that I would just like, I wouldn't even read it because it's just obvious, right? Like you want to protect workers against AI or automation. That seems to be self-explanatory. But the reason why we still put these provisions in place is because the Supreme Court often refers to the declaration of policy when it interprets the provisions of the law. One big reason why they do this is to talk about whether some provisions are germane or relevant to the purpose of the law. So, for example, in the RH law case, this is Imbong versus Ochoa, the people who were challenging the RH law said that it violated the one subject, one title rule. The one subject, one title rule basically means that if the law's title says that the law is about a certain subject, you can't have irrelevant provisions that have no relation to the subject of that law. And the purpose of this rule is if you consider a law that has a title that is so unambiguously good, for example, it provides a lot of benefits to the poor at little cost to the rich, right? Like a rare unicorn of a law that somehow does that. These laws might be so uncontroversial that everyone would want it to be passed. So if you're, for example, a selfish or corrupt politician, you might have an incentive to hide some provisions that are more controversial and are irrelevant to that legislation. The fact that they're hidden means that it's difficult for the ordinary person to spot them and be informed. And not being informed of what the law says is a violation of due process because it comes across as deceitful, duplicitous. So in Imbong versus Ochoa, the RH law case, the challenger said, wait a minute, the title is about responsible parenthood and reproductive health, but its secret goal is population control. That's the reason why the Supreme Court looked at the declaration of policy and they concluded that actually population control is germane and not irrelevant to the title. Since the declaration of policy said that the purpose of the law is to promote sustainable human development, the court implied that sustainable human development requires that marginalized people be at least informed on modern family planning methods. So, in my opinion, if you link it back to this particular House bill, when there are doubts as to whether a particular provision is going too far or if it's straying from its intended purpose, you go back to the declaration of policy. Is this relevant to these principles?
What's stopping lawmakers from just making the provision vague, right? They can still sneak in a lot of things. The title can still sound very good, but in the provision, they might make it so broad that it allows a lot of like loopholes or sneaky inclusions that technically align with the provisions, but does not seem like what it should be doing based on the title.
Well, in my opinion, kasi, the first thing that you want to do is look at the title. This is the one subject, one title rule.
Mm-hmm.
So look at the title. But if there are doubts, that's when you go into the nitty gritty declaration of principles. I think it is more likely that there's not a real incentive to keep things vague.
Mm-hmm.
Because if it's vague, then it's more likely that the Supreme Court won't be able to justify that these rider quote unquote provisions, those irrelevant provisions, are actually related to the declaration. So
Like,
you want to be
mm-hmm.
consistent and clear with it so that it's easier to defend.
Like sleeper agent provisions.
Yeah. Sleeper agent provisions, we call them rider provisions.
Mm.
Yeah, because they're riding on another piece of legislation when really it's about something else.
Okay.
Yeah. I think another thing that is really interesting to me is the way that AI is defined. There are two characteristics that an AI has to fulfill. It's not an or thing, it's an and thing. So they have to fulfill both of these characteristics so that they will be considered AI. One is they have to make predictions or classifications using input data that can imitate intelligent behavior. And the second characteristic is learn from past behavior and past results and adapt accordingly. So I think this is where we hit a little snag because many use cases of AI already involve interpretation of input data. The first characteristic is easy, right? Like you can already imitate intelligent behavior like this. My issue is with characteristic number two because it says you need to learn from past behavior and past results and adapt. First of all, this might exclude non adaptive AI systems. So many AI systems, for example, in those early stages of development or simpler forms of automation, they do not have the capability to learn and adapt from past behavior. These are fixed algorithms. For example, many HR, human resources departments, they use AI, they use automation systems based on fixed algorithms that don't adapt or learn. So there's simple AI systems for, let's say, screening resumes, for example, looking for keywords in the resumes to look at, whether this person is what we're looking for. And another more important issue that I have with this definition is from a philosophical perspective, how do you even define learning? Because in human cognition, learning involves not just the acquisition of information. It's not just like, do you take in information, but also can you understand it? Can you understand that information and create new information by applying it to different contexts? And there's a difference between understanding information and acting like you understand information. So, Nina, we talked about the Chinese room experiment many times before.
Yeah, I'm pretty sure we have at least 5 episodes that discuss that or
I actually
more.
don't think we ever discussed it in an episode, though.
Oh, well, we just talk about it a lot to people who end up learning from us then.
Yeah, because the Chinese room experiment is a thought experiment. So imagine Nina is in a box and whoa, why does it have to be the woman? I am in a box. Okay, like I'm in a room and Nina's in the other side and we are trying to communicate to each other in Chinese. Another assumption that we should make is Nina knows Chinese, I don't. So in the room that I'm in, I have a huge book. I have a huge book that tells me if Nina gives you a message that contains these Chinese characters, reply by writing on a piece of paper these other Chinese characters. And so we communicate to each other by passing messages on pieces of paper back and forth. And so the book that I have, even though I don't understand Chinese, contains every single response that I could possibly make. Like it's a list of rules so comprehensive that like this is really how you interact with someone in Chinese, like according to what the book says. And from Nina's perspective, who knows Chinese, I might look like I am able to understand Chinese and write Chinese, even though I really don't. So that's the difference between acting like you can understand and actually understanding pieces of information. And that's the difference between what we call soft or weak AI and hard or strong AI. A soft or weak AI is just something that pretends to understand. For example, like ChatGPT, or to a lesser extent, like chatbots, stuff like that. Those are weak forms of AI because they act like they can be a human, but they're not really human because they don't really understand it.
They're just acting on impulse.
Yeah, they're just acting on inputs. They look at their rules, their book of how to respond, and then they spit out something like that. So, for example, ChatGPT, if you give it a prompt, they look through their database and they try to make predictions based on what is the most likely next word to be used, and then they spit it out.
Okay.
So that's a difference. Weak AI does not understand things. Hard or strong AI is actually conscious. It can actually understand things. It doesn't just pretend to understand things, it actually understands things. And we don't understand how understanding works because understanding implies consciousness. But we haven't yet been able to identify what consciousness is or where it comes from. This is what David Chalmers calls the hard problem of consciousness. Like we have no idea what goes in it because we are able to like fabricate or recreate huge parts of the brain, right? Even to like the cellular level. We theoretically can do that. But this man-made brain is still not conscious. Like it can't feel emotions or anything like that. So like we have simulated things like deep learning, machine learning, neural models, right? But none of them can feel things. None of them can actually demonstrate understanding to the level of human understanding. So I think at best, because of characteristic number two, which requires that they can learn, it excludes the most prevalent uses of AI in the labor market because the most prevalent uses of AI in the labor market just involve soft AI or weak AI, not hard AI. At worst, this definition excludes everything that you might consider to be AI today. And the reason why it might exclude everything that you might consider AI is because there's also a debate among neuroscientists and philosophers as to whether we could ever give an answer to the hard problem of consciousness. So, is there an out? Um, I think there might be an out, but I'm not sure because I'm not the Supreme Court, right? Like, if someone brings this up, like they fired someone because of AI, and they argue before the courts that, well, this isn't something that can learn from past behavior, it can't adapt. It's just a robot. It's not hard AI or it's not strong AI. Maybe the Supreme Court would believe them and basically like make the entire law, if ever this is passed, as is, useless.
I could also see a lot of people making loopholes. For instance, maybe they do have AI that can cause the harm that this bill is trying to prevent. For instance, discrimination, etc. Yes, they have an incentive to keep updating it. But if I manually update it myself, right? So I input the data. It's not
Yeah,
learning. I am teaching it every step of the way. Like, okay, this is a new uh code. This is a new provision. This is a new rule that you must follow. Therefore, I can argue it's not learning.
you're just putting more input
I'm
data.
just putting more input data. It's
Yeah,
just following my command.
yeah.
Mm.
So Nina's absolutely correct. So is there an out? I think optimistically there might be an out. Because first of all, I'd say laws are generally interpreted according to their most common or plain meaning. So if the law says, for example, if the law says killing another person with criminal intent is a crime, and it does, it's not an example. Like, so, yeah, the law says killing another person with criminal intent, that's illegal, that's a crime. The court doesn't need to delve into the philosophy of what intent means, even though it has a lot of the time. The rule that the Supreme Court uses is the fact that you did it already makes a presumption that you intended for it to happen. Similarly, I can make an argument that it doesn't matter what understanding or learning means in a psychological or cognitive level. What matters is whether they can act like they learn.
Mm.
Yeah. Another argument I could make is I'd say it would be absurd to adopt an interpretation that makes the entire law useless. There's a principle in statutory construction for people who are not into law. Statutory construction basically means it's the method by which legal professionals interpret and understand the law. There's a principle in statutory construction that says the spirit of the law should prevail over the letter of the law. So, if all AI systems would be excluded by this interpretation, it would be unjust to adopt that interpretation.
Mhm.
But again, I'm not a Supreme Court justice. I don't know how they would value these arguments one way or the other. And in the past, actually, there have been some cases where you would think that this particular interpretation would be absurd, but they still adopt it. But that's just a matter of opinion as to what
Mhm.
absurd means. So the example that I think about most often is premature campaigning. So uh, a few years ago, there was a case that I was gonna say Panera, like Panera bread, but I think it's Panera,
Okay.
Panera versus Comelec, where the Supreme Court said that until the campaign period, candidates, even though they have filed their certificates of candidacy, are not considered candidates. So they can't possibly do campaigning until the campaign period. Because before the campaign period starts, they're not candidates.
Mhm.
But there's a provision in the Omnibus Election Code that says you cannot do premature campaigning. So the Supreme Court, by adopting the interpretation that you are only a candidate when the campaign period starts, this entire provision about premature campaigning is just rendered inoperative.
Because you're not a candidate yet. You're just
Yeah,
promoting yourself as a person, I guess.
exactly.
Ah.
So I think that it might still go either way, right? So the reason why I want to bring this up is number one, definitions really matter. And more importantly, for my philo enthusiast agenda, the philosophy of mind, it matters even in the context of the law. Philosophy is not an airy fairy field because if this bill passes as is, and courts end up ruling that AI in the bill is limited only to strong AI, many, many, many laborers will be put in a very bad situation, in my opinion.
Hmm.
Yeah. Moving on. There is another cool provision in Section 4. Section 4 says that employers can adopt AI so long as the data collected for the AI are compliant to the Data Privacy Act. Under the Data Privacy Act, data processors, so people who are like using and interpreting data, they can't use personal data without the consent of the owners or the generators of that data. So, for example, if the AI takes your personal information without your consent, and processes it without your consent. GGN. That's exciting to me because a big problem with AI is you don't know whether the information you give to people will be used as training data without your consent. But one thing I want to emphasize here, though, because it's just a Data Privacy Act, is that it's limited to personal information. Personal information is information that can identify the person to whom that information refers. So these could be names, it could be addresses, emails, ID numbers, physical characteristics, stuff like that. So if it's information that is attributed to you but does not identify you, that might not be personal information and it won't be covered, right? So if it's a piece of art, for example, that's not necessarily personal information. Mid Journey could be allowed to crowd out pub people and design people under this law, potentially, in
And
my opinion.
and it might still be able to use metadata, right? Which is technically something very, very personal. It's about your browsing history, it's your preferences. When you look at analytics on Facebook, for example, for those who own like Facebook pages, you get to look at, the percentages of people that tune in, how many are male, how many are female. And while that cannot be attributed to you specifically, it is still something that you know, says a lot about you. So that might also be kind of tricky. A lot of AI doesn't look at your personal data anyway. I don't think Midjourney or ChatGPT look at your personal information.
Yeah, they don't.
Mostly they operate on what we call metadata, which is data about your usage of the internet and what, the analytics of what that says about the people.
Yeah. Another part of Section 4 is that it says that the use of AI in operations, whether it's like as an administrative tool or as part of your workflow, the use of these AI systems is regulated through something called an AI governance policy, which provides employees with guidelines for how the AI will be adopted and used in the workplace. So that's something that's very interesting, but I feel like it's a little bit limited
Mm.
in some respects. People can debate us about like, well, there's a reason why it's just about data privacy because other AI systems, they're like less dangerous if they don't look at personal information, stuff like that. And maybe the proper recourse with respect to Midjourney or ChatGPT is actually like copyright law or something like that. Section 5 is the next one. Moving on to Section 5. This is entitled Prohibited Acts. Section 5 is the reason why I decided to make this. Like I told Nina about it and I said, Nina, did you know that there are these prohibited acts in House Bill 9448? This is so exciting. Let's make an episode on it. Section 5 says that there are two actions that are prohibited. The first prohibited act is for employers and recruiters to use AI as their only basis in the hiring and termination of employees. So, if that's only thing that they use in the hiring or recruitment process, that's not allowed. Additionally, and I'm reading from the law itself here, any use of AI systems during the processes shall be directly supervised and complemented by human oversight. I think that this is nice on a surface level, right? But I can think of loopholes, right? Nina, can you think of loopholes?
Yeah, many.
Then, so, for example, it says that um, it says that you just shouldn't use it as your only basis. So, a lot of hiring takes place in phases. Phase one is resume screening, for which a lot of companies use AI, especially like really big companies. They use AI to screen your resume. The next phases have more human intervention. So, like human interviews. In these cases, the AI used during phase one might hurt poor people, as we've seen in the United States. People who have non Western names or names that sound black or Muslim, right? Even though the use of AI in this case might hurt marginalized members of our communities, the employer can defend itself by saying, that's just phase one. We have a variety of phases in our hiring process, and AI is not the only way that we hire and terminate an employee. So you can defend yourself by saying that's just one part of the process. It's not our only or primary basis in hiring.
But I could also say another loophole I thought of is there is human intervention because they probably were the ones that designed the AI to be used in this particular way. It might be discriminatory, but it wasn't the only basis because a human in charge in AI in HR was the one that created those provisions or those standards, right?
Yeah, actually, when I said like complemented by supervised and complemented by human oversight, I think the bill could have been more specific as to what it means to do human oversight. Like,
If you
if,
watch it, is it enough?
yeah, if you watch it is enough. If you press on, right? If you say, okay, let's use this AI to screen resumes, is that already human oversight? Right? Like what are the extents to which we regulate or require oversight?
But again, we are not experts. There could be fair interpretations of this. We are just pointing out based on the language itself how we would find loopholes if we were, ever to try to break this law to be.
Also, if you're part of the drafters, like if you're one of the drafters, specifically Arjo at our honorable representative Arjo Ataide,
Hi.
who's definitely listening to
Of
this.
course.
Um, first of all, I mean, I'm a member of the Aldub Nation, but I respect you for this bill. I want to criticize you for the way that you respond to transport strikes, considering that you have so many cars and are contributing to the transport crisis. I think they had like half a dozen cars or more, something like that. But anyway, hindi naman sa bitter ako, no? Maybe a little bit. Maybe a little bit. I'm just joking. Um, but anyway, right? So that's one thing that we are concerned about with Section 5. Another thing that we want to talk about, the second prohibited act under Section 5 is for employers to replace workers with AI or reduce salaries because of AI or reduce benefits because of AI. And so I wanna bring it back to the labor code a little bit because again, employers are authorized to terminate employment due to the installation of labor-saving devices. The Supreme Court understands these devices as machinery that improves efficiency. So AI, insofar as it can improve efficiency, it allows a single person to do the work of two or more people, right? So AI can be understood as a labor saving device. So the bill, if passed, would serve as an exception to this rule. So the full rule would now read employers can terminate employment on the basis of installation of labor saving devices, except when these labor saving devices are considered AI under this law, if it becomes a law.
I can still find some loopholes here, though. I think that it's a very common trend, for instance, that even if I cannot replace you outright, one, I might just limit your ability to climb the corporate ladder, like put a cap on your salary or saying, I no longer need to promote you. It's not a reduction, it's not firing. It's merely, I'm going to retain you, but all future opportunities are lost now to you
Of course, they
because
would never say that.
of course, they will never say that. I'm just saying, if I was an employer and I was trying to find loopholes, this is one angle I would look at. Another thing, and this is sadly very common practice, both in the Philippines and even in other countries, especially for bigger corporations, they try to make you redundant, right? They don't fire you. They do something that a lot of Gen Z people now call quiet firing, which is reducing your work, reducing your opportunities to advance yourself or to build your resume, to build your CV, so that
Dead end
eventually,
na.
yeah, either dead end or they can find another reason to fire you. That is not specifically AI, but the real goal was we want you out of here so we can replace you with AI.
Yeah.
So eventually they either have you quit because maybe you feel like nothing's happening, or maybe they go the other route, right? They give you so much work so that you feel pressured and you underperform, and either you resign or they fire you. And I'm sad that I know this because I know a lot of people that have encountered this, and I see a lot of posts on TikTok and Twitter about individuals who felt like they were put in these situations with the end goal of having them, leave the company eventually.
Ako naman, as a rule, I do not want to.
Assume the worst.
No, I don't want to apply anything I say to like real situations
Mm.
because that might be considered legal advice. So I'm not. Again, this isn't
Kyle's
legal
not,
advice.
yeah, Kyle's not saying anything. It's me saying things. Kyle's not giving legal advice. I'm not giving legal advice either. I'm just like acting like a reporter and saying what I see.
Yeah. So another part of Section 5, specifically this second paragraph, is that it gives not necessarily a loophole, but an exception to the rule.
Mm-hmm.
So the rule is you can't fire someone or, lower their salary because of AI. It says here, unless there's an equivalent alternative employment opportunity for affected human workers. So,
That's actually pretty good. Like, we may just replace your role, right?
yes, but I feel like it could be clearer. Kasi I could probably say like there are other like positions available,
Just not here.
just not here, right?
That's
So
so
I feel like you have to be more specific that there needs to be an equivalent alternative employment opportunity within the same company.
Or was it with the same place of employment, right?
Yeah. So there, I think that's nice asterisk.
Mm.
There's an asterisk. Another exception can be found in section 6. And this rule is qualified by section 6. So again, like I said, if it's a labor saving device, generally you can be terminated because it's an authorized cause under the labor code, except if this bill is passed, the labor saving device cannot be AI,
Except,
except if there's an alternative, employment opportunity. Another way that the employer can remove a person from their employment is under Section 6. It's no longer about the installation of labor saving devices, but rather retrenchment. So Section 6 says the prohibition set forth in the previous sections does not apply in cases of retrenchment. So, what is retrenchment? Retrenchment is reducing workers because of poor financial returns. So, if you are like suffering business losses, yeah, and you want to cut the operational costs in terms of salaries, retrenchment is another authorized cause. So, if a worker is replaced by AI, that will not be allowed as a general rule. But if the worker is replaced by AI because the employer is facing significant losses, it might be allowed. But for retrenchment, under this bill, there are additional requirements, which are that the losses have to be substantial, they have to be real or imminent. Very importantly, they have to be proven by sufficient and convincing evidence, and that the retrenchment is reasonably necessary to prevent expected losses. These are just restatements of criteria that are found in case law, jurisprudence, Supreme Court decisions about retrenchment.
so it's not adding anything new necessarily. It's just referring to a law that already exists, right?
Yeah.
Okay.
Yeah. So, kasi even under the labor code, retrenchment is okay.
Yeah.
But the added criteria or requirements that it needs to be proven by like a lot of evidence, stuff like that, those were established by the Supreme Court in jurisprudence.
Okay.
Yeah. Another thing that might be understood as a prohibition can be found in Section 10 and Section 11. Section 10 says that employees must be informed ahead of time if employee evaluations will be done with AI and to secure the informed consent of the employee. Section 11 of the bill says that employees have the right to refuse and undergo AI driven evaluations, and they should not be discriminated against because of their refusal. My issue with this, okay, first of all, I like this. My issue, if I were to nitpick a little bit, is that it only applies for people who are already employees. So the people who might be harmed by biased AI programs and the resume screening phase of hiring, they might not have a remedy. Another possible issue that I might have is that the discrimination thing might be hard to prove. Like, it's perfectly possible, in my opinion, for an employer to get annoyed by a worker who refuses AI evaluations. Because if you're an HR professional or if you're the employer, dagdag work yan eh. Like, you'll be given more work to do because the worker refused AI evaluation. And that frustration might directly or indirectly end up with the employer or the HR professional giving harsher evaluations, even if officially it will be because of something else, like their attitude or company culture fit or something like that. Finally, and again, this might be a nitpick, I would have preferred if these sections were incorporated in the list of prohibited acts.
Yeah, it's kind of strange that there's a big jump, right? From section 5 and 6, and then you read a bunch of other things. You have to go to section 10 and 11. Um, for me, I also find a little nitpick here. Again, very, very promising section, right? I think that all of these things are rather necessary, but my issue with it would be that, again, they can just find other ways to fire you. Kyle gave a very perfectly clear example.
Hypothetical example.
Yeah, hypothetical example. But even before you are hired, right? Like Kyle already mentioned this, it only applies to employees. I don't think it's common like when you're applying on LinkedIn or those other like career.ph. Not sure what those other sites are anymore. It's been a
Job
while.
Street.
Yeah, it's been a while since I did like my aggressive sending 300 applications.
Did you send it?
Yeah, of course.
Wow.
It's hard being a new grad. And if you're in that situation, I sympathize and I empathize. But basically, it's difficult because there's no requirement for them to say, oh, by the way, we're AI screening the first set. and you might not even get an email from us. So you have no idea to know. You have no way of knowing what tool was used. And I have no patience to email every single company that did not give me a call back or did not schedule me for an interview to figure out what was used to determine I wasn't qualified.
Oh,
Correct?
that's for hiring stage.
Yeah, that's for high risk stage.
Yeah, that is a big issue because it's often a black box,
It is.
right? Like if you apply to a company and they're using AI to screen resumes, chances are, I'm not saying all of them do this, but chances are they're using a software that's outsourced from another like creator.
Mm-hmm.
And so like who will be held accountable? Will it be the employer who is using the program or the creator of the program? But more than that, because it's a black box. A black box in computer science is when you're looking at
The thing.
the program, you don't necessarily know what's inside, how it works. And so one problem with generative AI lately is it might spit out some, conclusions or, responses that even the creators themselves had no idea how the AI got there.
Yeah.
Yeah.
And that's a issue, right? You might say, well, there are remedies for this. You can reach out, but what grounds do I have, right? Like I can't just demand or question a company or even sue them, right? Because I did not get hired. And a lot of people will not go through that effort because, nakakahiya. Like, what if there really was a legitimate reason for me not getting that interview? And there's really no way of me knowing. So,
Yeah, but at least if you're already an employee, you have to be informed ahead of time that your evaluation might be done with AI. And you need to give your informed consent before you do it. And informed consent also means like what AI will be used.
yeah. And like, again, I am not criticizing the bill. I think that it's a very promising bill and it leaves a lot to be asked for still. But I also understand it's very hard to deal with these issues in a bill, especially since these are issues a lot of people are still debating, right? So I'm not expecting the bill to have answers to everything. I'm just pointing out that the fact that things are unclear right now in terms of what AI is, how it works, the fact that it's a black box to everyone and even the creators will make this a challenge. I just hope we get to a stage where those challenges are met and these questions are answered. But at this point in time, there's still a lot to discuss. And the point of this podcast episode, obviously, is not to bash this bill. We really like this bill. I think I would love to have something like this pass, but you just want to be very careful and recognize that there's still a lot that it can do.
Yeah. Speaking of things that it does that are very promising, one thing that I want to highlight is section 9, which is about transition assistance and reskilling. Because section 9 says that employers, even if they're allowed to terminate due to AI, they have to provide transition assistance to the workers in the form of severance packages or extended benefits or support for skills development. So I think like even if you are retrenched because of AI, the employer still has to give you a bunch of stuff. Already the law already says that you need to have severance packages, even in the case of retrenchment. But one thing that's promising is you might be able to get extended benefits. You might be given more support for skills development.
Does it state what those extended benefits are and what the support for skills development looks like, or is that just a restatement of something that's already created?
So the extended benefits, it doesn't say what that means. But support for skills development, let me check really quick.
Okay. Do, 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 do. Should we put elevator music here for like 5 seconds?
Yeah, maybe. Um, so yeah, it says government agencies shall establish reskilling and upskilling programs to facilitate the transition of affected workers into new roles within the evolving job market.
Okay, still kind of vague, but at least they clarify that it has to be relevant to the evolving job market. Like I can't just reskill you in like writing better.
Yeah,
Yeah.
exactly.
Mm.
Um, section 12 says that the Department of Labor and Employment has the authority to oversee and compel the submission of AI governance policies to ensure compliance with existing laws, rules, and regulations, and are compliant with the ethical standards of business and industry in consultation with relevant government agencies or offices. And I think this is really good. This is really good. What I would suggest, I'm not the lawmaker, but if I were to suggest something, I would expand the role of the Department of Labor and Employment a little bit to have more power with respect to like dun sa AI governance policies, right? Like give them more discretion as to like what practices can and can't you do.
I really think this is a great first step, though. Like a lot of these things, and I'm sure this has happened in many other laws in the past. Like you pass something initially, you can amend, you can change, you can add on to it, you can make something that will supplement it, right? Is that common practice?
Um,
Or is it this? Like, if this is it, like, you can't add to it, you can't clarify. That's it.
it depends. It
Ah,
depends. Because here kasi in section 16 of the bill, the implementing rules and regulations will be promulgated by the Department of Labor and Employment. But what it can add there depends on what the law says,
okay.
right? So you can only like make rules and regulations that aim to implement the law, but you can't go beyond that.
Okay. So let's say we're not necessarily going to be allowed to change it, but we can clarify or maybe give more details on certain things that have already been stated, as long as it's aligned with everything else that's stated in this law. Yeah.
Yeah, yeah. So anyway, in conclusion, we think that this bill is kind of exciting. That's why we wanted to talk about it. And it's not something that we are attacking anyone for. I just want to make this very clear. We are very supportive of these kinds of, initiatives from our legislators. But I think that personally, the effectiveness of this bill, if it turns into a law, might hinge on how terms like AI and learning are interpreted and applied. And the nuanced and evolving nature of AI means that legislation must be, on one hand, very flexible, but on the other hand, very precise as well, to avoid loopholes and to avoid unintended consequences. So, Nina and I, we celebrate this attempt, but we also have greater hopes that in the next readings and during deliberations, in debates, in debates, they might be able to improve on this bill even more.
Yeah, I think it is a great lesson as well in terms of being clear with models, right? Being clear with the policies that you are trying to bring into reality. It's also a discussion of precision of language as well as the different ways things can be interpreted. So again, these are useful skills whether you are interpreting a bill, whether you are in debate, or whether you just want to hypothetically discuss different scenarios that might happen should this thing pass, right? So thank you so much for listening. I hope you enjoyed this. We promise one day we will have a full episode, probably discussing AI in more detail. But I think this is a great way to hit like two birds with one stone. We managed to talk about AI. We also talked about something happening in real life right now that we find fascinating. So we hope you enjoyed.
Yeah, so that's it for this episode, whether it's bonus or an actual episode of Debatable. We'll see you in the next one. Bye.
Bye bye.